All right, ladies and gentlemen, if we could get started, I want to thank you again for joining us today. Given that we've bored you with Chapter 11 issues and Chapter 7 issues that are the last few months that are either esoteric or not applicable, was able to cajole our speaker today, Mr. Dellutri, into leading us in a spirited discussion of what I called emerging issues in Chapter Chapter 13 cases. And so I'm going to let Carmen take the lead today. I have applied for CLE approval for today, and the bar has acknowledged it. I expect to get a number within a week or so, and I will send it around. I didn't hear from Judge Delano whether she had any announcement. Does anyone have anything before we let Carmen begin? All right. Our next meeting is in May, and we have, I think, Jerry McHale is going to talk to us about some of his more interesting Ponzi scheme cases. If you don't follow his cases, a lot of times you can turn on to CNBC and American Greed in the middle of the night, and you'll see, at least once a month, either Jerry or Sunit Kapila in one of their cases. So that should be entertaining. I'll send a reminder for that. But like I mentioned before, our speaker today is Carmen Dellutri. Carmen is well known in the bar. He's starting to get some gray hairs. He's going to succeed Richard and Jeff as the Dons pretty soon. And Carmen's the founder and president of the Dellutri Law Group.
Moving on.
All right, move on.
Thankful.
He doesn't need an introduction.
No, I would really prefer not. Yeah, let's move on.
All right. In Chapter 13 in our office, I don't know how many of you guys file a lot of them, but we're seeing a lot of issues come up since the new form plans coming out and the new first day orders coming out. And it's things that, we're asking questions and saying, what exactly does the Chapter 13 trustee expect from us? And what are we required to file, or do we have to amend things? And the first issue that came up was tax refunds. For me, tax refunds are a huge issue. Because let's say you have a debtor who relies on the tax refund to pay their house taxes or to supplement their income the whole way through. We have Chapter 13s who have a negative budget. On Schedule I, they have $1,000 a month, and their expenses are $1,200 a month, for example, but they're relying on that $2,500 tax refund to supplement the income. But now, under the first day order, we're required to take that $2,500 and send it directly to the Chapter 13 trustee, no ifs, ands, or buts. That creates a huge hole, which hasn't been addressed by the first day order or the plan. Likewise, what if the debtor's going to use that money to pay their taxes with? Their property taxes on their home. So you have several scenarios, I could probably think of about 5 more, where the debtor is put in a significant disadvantage because of the form plan that we're being told we have to use and the first day order. Sir?
Does the trustee make a distinction between whether it's withholding refund or whether it's the earned income credit?
No. There's no in the order, in the first day order and the plan, there is no distinction between earned income tax credit, and it says all refunds must. There's no distinction. And that's a great question, because this is something that came up to us. Now the question comes up is it additional income, or is the refund an asset of the estate? If it's additional income, are we required to go back and amend CMI when they get the refund and submit a new budget to the trustee? Or do we have to go back and amend Schedule B now because they have a new asset of the estate? And the 11th Circuit case that says every new asset you get, you got to go back and amend Schedule B. And that's an issue that we need to address, because I don't want to be caught when they say, oh, you didn't put your tax refund on Schedule B. And I go, well, but then you got the first day where you go to the meeting of creditors. And the trustee issues his unfavorable recommendation. We've all got them. And it says the debtors are not contributing all disposable income to the plan. Well, if now they're getting all our disposable income and they're getting our tax refunds, what else is there to give that we're not giving? So that's an issue. It's not that it's a huge issue. I just want to know how to address it, because I can set up my game plan from day one. If I know I have a debtor with a negative budget, then I can say, okay, on this case, I'm going to have to tell the trustee immediately, maybe in my pleadings or in my Schedule B or in my Schedule J, my expenses, that I have a negative budget, but I supplement it with the debtor's tax refund. But I'm still required under the plan to submit it to the trustee and the first day order, which is kind of, problematic. And again, it's not that I'm trying to push one way or the other. I just want to know what the best practice is so that we can all establish it in Fort Myers and we do it all uniformly. And this way there's not a problem.
Now, if it's an asset of the estate
Yes,
and it's not additional income,
yes.
then wouldn't it not be subject to turnover because the debtor maintains control of all property of the estate?
I would like to think so, but I don't know the answer on that. I don't know the answer because the form plan and the form order say we have to turn it over. So that's a good question.
What was the genesis of the new provisions in the plan, in the order, form plan and the form order?
What do you mean was the
Where
genesis?
did it come from?
I have no idea.
I think at the time,
Dave would probably be
we
able
were
to address this
arguing
because he
in
was on the steering
confirmation
committee.
whether or not,
Credit card company.
at the confirmation, we were already arguing, do we commit the tax refund or not? And I think the court just put a blanket
order on it.
Puts the tax refund in.
We don't know where the thing came from, that statement came from, but now it's mandatory in the new plan and in the new first day order. But that's a great question. Then the question is, with the tax refunds, is there a threshold amount where it becomes negligible? Let's say you get a debtor who gets a tax refund of $200. Well, then, if there was a floor set, let's say $250, where the debtor could just keep it, rather than say to me, Carmen, I need new dental work, my teeth are falling out, can you file a motion to protect my $250? So I file a motion, I charge a debtor $250 to keep their $250, but their plan payment now goes up another $10 a month, which they can't afford. And to me, it becomes, all right, what's fair to the debtor, and what becomes, I guess, negligible would be, on every case, a different status, because I got some debtors getting $7,000 back, and some debtors getting $50 back. But the order doesn't allow for anything like that. And if there was some kind of floor where we could be in, where we could just tell the trustee, hey, here's our tax refunds, it's below the floor, boom, send them an email. I mean, for me, I would like to see the Chapter 13 trustee set up separate email accounts, one for tax returns, one for profit and loss statements, one for amendments, that we could just send those to the separate email addresses, and we know we've complied. Because we've all had, yes, Greg?
Well, they kind of have that under the new portal system.
Okay.
That they're going to, you can allocate for 341 documents or tax returns or confirmation information. So they do have that kind of breakdown. I know there was some discussion at one point where they were going to try to adopt something like you were saying, where you can have a dialogue with the Chapter 13 trustee rather than having to go through the formalized process of
Right.
filing a motion. I don't know where that stands right now, but I know there's been talk about it.
And again, that's the next thing on my list is, do we need to call the trustee, the Chapter 13 trustee's office, on every case? Because every case is different. Then what happens? Not only are we taking it off the shelf, now we got to take the trustee's office. Somebody's there has got to pull the case, look at it. If it's a debtor making $1,200 a month, or if it's a debtor making $5,000 a month, there's going to be a difference as to how we're going to handle this. And there's no easy answer to these questions. I'm not here trying to say these are answered. What I'm looking for is a best practice. What would the trustee like us to do as a bar to take care of these problems and address these problems as to how we're going to do it? And again, the reason I separate, I say set up separate email addresses is so that you have a direct line to the trustee and their office can work more efficiently saying, hey, but if they've got it in the portal system where they can break it down, the only problem we have is that sometimes documents that we send to the trustee don't always make it there, or they're telling us we never got those. And that's, I don't know where the breakdown is, but that happens. So I mean, and again, what I'd like to do is, if any of you guys who are Chapter 13 practitioners have any questions like this, send them to me. I want to get these issues before the steering committee. See, the way the steering committee works, Dave Feynman from our office is on the steering committee. They get an agenda from the judges about what they're supposed to talk about. Many times, Chapter 7 and Chapter 13 issues that we're having as the debtors bar never make it to the agenda. And we don't have any input on what's on the agenda. So that's kind of concerning. Okay, does anybody have any issues with tax refunds or tax returns that they're thinking about that I didn't talk about yet? No? Good. Now, let's move on to automatic stay violations. I don't know about your office, but we've been seeing automatic stay violations go through the roof in our office. And they're intentional, and it's just the volume has increased dramatically in 2016 2015 as well, and 2014 seemed like there was a lull. But now they're back in crazy form. And I want to address this. I'm glad the judge isn't here. Sorry, it's on videotape, but what's the incentive for the debtor to pursue a stay violation in Chapter 13? There's virtually none. There's virtually none. I mean, again, I don't mind saying this because I've been saying this for a while. Chapter 13, in my opinion, is turning into a debtor's prison. And if you think I'm nuts there, think about it for a minute. Let's say I'm a Chapter 13 debtor and it's football season. My boss calls me on a Saturday and says, come on into work today, I'll pay you triple time. Nope. Why? Because if I make more money, I got to pay more to my creditors. I don't get any benefit from it. If I make an extra $1,000 in overtime this month, I got to kick that to the Chapter 13 trustee to pay my creditors. I'm better off sitting my butt on the couch watching Oprah than I am going out working overtime. Why would I want to go out and get a better job? There's no benefit to it. I work harder, I pay more to my creditors. In other words, Chapter 13 has become, you make more, we take more. And it becomes a game to me where we're always taking, and we're not saying to the debtor, you're working towards a fresh start, and you have the opportunity to go out and live the American dream again. We're giving you this chance to do it over, but then we're gonna basically keep our thumb on you for 5 years. And there's no incentive for you to go out and get better. Now, carry that forward to the stay violation. Debtor gets harassed by Bank of America. Sorry, Bank of America, but you're a violator. They get harassed by Bank of America. We filed a motion, or the adversary proceeding, for a stay violation. Judge may give us our full damages, may give us attorney's fees. So I get to keep my attorney's fees for doing the work. Debtor gets $1,000 in damages. Now we got to compromise with the Chapter 13 trustee as to where this money goes. Do I get to keep some of it? Do I get to keep half of it? Why would the debtor want to take time off of work for a deposition when they're not going to get compensated for it? Yet, at the same time, why should the creditor who's violating get away with it? And then thirdly, when the money does come into the estate, why should the creditors who filed claims get paid because of another bad creditor? So you think about these issues and you say, okay, Mr. Debtor, come on in. Mr. Feynman, you're my client, come on in. I know you've been harassed 100 times by Bank of America. I'm going to sue them. And you're like, okay, what's that mean? Well, you got to go through a lawsuit. You might be called for a deposition. You're going to have to answer interrogatories. You're going to have to, do this, do that. You're going to have to appear at a trial. Okay. What's in it for me? I can't really guarantee anything. What happens to the money? Well, I get paid. But the money goes into the estate. But what happens to that money? Does it pay down my Chapter 13 plan? No. It's going to be an additional distribution to your unsecured creditors.
One of which
is Bank of America, who's going to get paid more on their claim in the Chapter 13.
Well, you can have preclusionary effect. I've had violation of state orders where there was agreed that there'd be a distribution, but not to the offending creditors. So
And
you can't incorporate language.
I understand that. Not in all cases, but you can't guarantee it to your client at the beginning of the case. You can't do that. And that's the problem. So I'll just stay on the couch, checking them channels, let the phone ring. I like stay violations. In our office, we file lots of stay violations. We sue a lot of creditors. I find it to be very lucrative. But it's got to be something in it for the client. It can't just be about us. And if I can't guarantee my client a return on their investment of time, then why do it? Why do it? Do I have an obligation to my client? Sure, I got to bring it to the court's attention. He's being harassed. Now I have an obligation to do this. So I'm basically using my client as a pawn to make more money. I don't know. Where's that in the ethics books? Do I have to do that? Do I have to put my client as a mule to make money for the other creditors? I don't know about that. That's a tough one. That's a real tough one. And again, it's my personal thing as a debtor's attorney. If I was a creditor, I'll feel differently. I'd be saying, yeah, you have to do that, Mr. Dellutri. You have an obligation to your debtor and to the bankruptcy court as an officer of the court to go out and pursue these violations. Maybe. I don't know. That's a good question. Their attorneys could probably do it. I guess. I don't know. If the debtor's being harassed and it's property of the estate, should the Chapter 13 trustee be forced to do it? I never thought about that before. have to think about that one.
Well, again, if it's property of the state.
The trustee's not
How
obligated.
the trustee's able to take control of the asset.
It's a good question. Something we have to think about and research. I don't know. Right off the top of my head, I don't know the answer to that question. And again, it's a good question. And again, these are all good questions. I mean, for us, these things come up, and you might not think about them until you're actually witness it happening in your case, and you're like, wait a minute, this doesn't make economic sense for my client, for the estate, but it does make sense if I'm the trustee, because I want to distribute more money. And it does make sense if you're a creditor, hey, I'll just sit back and get more on my claim because the debtor's doing all the work. Okay, I'm okay with that. Okay, and then we got the, okay, we can talk about that.
Can you work out a deal with the Chapter 13 trustee before you file your suit?
Well, in some cases, I file an application to be employed because I'm always afraid if the debtor converts to a Chapter 7, I may get zipped. So you file the application in abundance of caution, and we usually do it on a contingency fee basis or a fee shifting statute where we'll be paid our fees out of it. The judge will approve it with no problem, but the problem is what's fair? Let's say, for example, it's an egregious violation, and it's at $10,000 of actual damages. If the client has $10,000 in actual damages, why should the estate get any of that? They're actual damages.
Why is it different though than from a personal injury claim where a debtor has a pre-petition personal injury claim where they have
I am so glad you brought that up. I don't know where the splitting of 50% came from, but under Judge Shermer, there was no splitting. Under every other judge we had before Judge Delano, there was never any splitting of 50%. I never paid the trustee a dime on my personal injury cases until Judge Delano said we have to pay 50%.
What are you talking about, 13?
Yeah, in 13s. They want half of the personal injury settlement. I've never heard of this before.
But there's a difference in 7 with pre-petition
Correct.
claims.
Yeah,
and
pre-petition.
post-petition claims.
Pre-petition claims in 7 I've never had a problem with. Post-petition 7s is not an issue. But in the Chapter 13s, all of a sudden now, we have to give half to the case. And I find that absolutely shocking. Because, when I was in front of Judge Shermer, the Chapter 13 trustees brought it up and said, Judge, we usually get half. And he said, why? This is the debtor's damage claim. I said, thank you, Your Honor. We walked out. It was over that fast. These are debtor's actual damages. The money that comes in a personal injury case is for the debtor's pain and suffering, future care and medical treatment. If you take that money away from the debtor, you've harmed the debtor. The debtor would be better off dismissing the case and taking the money. What good is that, though? The debtor shouldn't be penalized for being in a car accident that wasn't their fault. So, for my purposes, you're right. These are issues that I like to say that need to be addressed. But there's no case law that I found that it's mandatory to contribute 50% of a PI settlement or any type of settlement to the estate.
Are you talking about 13s?
Yes. Yeah, in 13s tonight, of course, not in 7s.
In 7.
Now, I'm sticking with just 13s today. But yeah, I agree with you. In a 7, it's a different matter. You control it. It's an asset of the estate in Chapter 7, a pre-petition personal injury claim. And we've never had a problem with that. Never. This is a different ball of wax because in Chapter 13, we have to disclose it after a pre-petition or post. And then the question is, who gets the money? Because then we, as a personal injury attorney, I have to decipher in a pre-petition cause of action how much of the medical bills were pre-petition because they're subject to the bankruptcy, and they've got to file a proof of claim, and if they don't get paid. And post-petition, how much of that was medical treatment, which I needed to settle the case. Because I believe they should be entitled to that. That helped me settle the case. It's post-petition medical bills. But if the doctors don't file their proof of claim, I have no mercy for them. They know how to play the game. They shouldn't get paid that money. In some cases, depending on what type of injury it is. I wouldn't, if I had a neurosurgeon who was seeing the debtor and then he needed to do a surgery post-petition, I want to pay that guy because without his bills and records, I'm not going to settle my case. So in every case, it's different, yes.
Well, I think also it depends on the case. Sometimes if you know the client will have to go and get treatment for
Correct.
another year, you can submit it to the trustee. And I had cases where trustee would allow a person to keep all of the money because we had a letter from the doctor showing what the expenses would be. And for the state violations, before you settle the case, you can call the trustee and tell them, look, if you're not going to let me keep 70% of the award, I'm just gonna drop the case and nobody's gonna get anything. So how about we're gonna make a deal before the settlement?
Let's go to two issues. The personal injury case, I agree with you, and I've done that in the past. That's why I was keeping all the money. When's the last time you tried that, Ivana?
Well, a year ago.
Okay. Things have changed. Things have changed. Now with the stay violation, the trustee doesn't make the call. He makes a recommendation, but it's the judge who makes the call. You see what I mean? You can ask for the trustee's permission, say, here's what I'd like to do, and you can give me your blessing or not, but ultimately the judge makes the call. Now, if it's a case like that where I think that the debtor should get all the damages, you're right. I'll call the trustee and say, look, this guy got blasted, he went to the hospital, blah, blah, blah. Here's what we need. And again, I haven't found him to be unreasonable. What I found, though, is a shift in the way these cases are being administered, but yet there's no law on the subject. It's just a change of policy in Chapter 13. And that's where I'm having, not an issue, but I'm saying, all right, what's the best practice? Should these things all be brought for a hearing? Should we just, if we're going to make a hard and fast rule about it, where'd the rule come from? What's the basis for the rule? What's the law behind the rule? But there is no law behind the rule. We're just creating a new policy. And when I have to tell a person, I got to give $50,000, or the other day, $40,000 to your bankruptcy clients, does that pay down my debt? No, that's an additional $40,000. When this person's limping out of my office, I feel kind of bad about that, because they're the ones who suffered a horrific car accident, no fault of their own.
Also, the settlement, you can separate what is the medical settlement, what is for future damages, and I don't think trustee can get any medical portion of the claim.
I believe you would be correct if you had a jury finding that we apportion this amount for future medicals. I agree with you. This amount for pain and suffering. When you got to separate the economic and the non-economic damages, I would agree 1,000% with you. If a jury finds it, I don't think the judge would overturn a jury's finding. But if you settle a case for $100,000, after attorney's fees and costs, there's $66,666. And I got future meds, or I got medicals of XYZ that are post-petition medicals. You see what I mean? Then there's a pot.
Advise the client to just dismiss Chapter 13.
It's their call. What if they're modifying their mortgage and they have to have 13? I know. You and I both deal with these issues on the same day. You're absolutely right, on a daily basis. And that happens a lot. And you don't want to prejudice the client by dismissing the Chapter 13 and then refiling a month later after they bought a brand new house. They put the $50,000 down on a house. They bought it. Oh, what happened? Oh, I just bought a house and now I'm refiling 13 again. It's just, you don't want to put your client in a compromising position, because they need the bankruptcy, yet they also have the personal injury claim, or the stay violation, or I like discharge violations as well. So, Dave, you put down attorney's fees for a modification of the plan? What was that?
Attorney's fees for basically anything.
Okay.
Post confirmation.
Okay.
You got to increase the amount that the debtor's paying, but it's, if they're paying disposable income.
Right. Okay, I see what you're saying.
How are you asking them to pay more? Then
Right.
You're not.
If we, let's say in our a la carte menu, after confirmation, the debtor needs a motion just to keep their tax refund. And the fee is going to be $250, but the debtor's already paying all their disposable income into the plan. Now they, instead of taking that money from the unsecured creditors portion and decreasing the amount to the unsecured creditors, assuming it's not a liquidation case, they're paying more than liquidation, take the $250 that would have been allocated them and pay the attorney with it. Meaning take the money that could have been gone to the unsecured creditors and use that to pay the attorney. Don't raise the debtor's plan. If the debtor's paying $100 a month to the trustee and it's all they can afford, but they keep a tax refund and they've got 5 months left in the plan, now their payment has to go up $50 a month to cover that $250 fee. Go ahead, Richard.
Why don't you just take it out of the refund? We take it out of the refund.
And you put it in trust and ask the court to pay it?
That could be the whole refund.
That could be the whole refund.
Okay, so the unsecured shouldn't have got it anyway. If you,
I would disagree with you on that.
if your refund is $400 or $500,
Right,
and you're getting $250,
right.
then you take $250 and you offer the $150 as compromise. And the point is, once you add a disposable income case,
Yes,
that's the only place the money could come from. Because you've used all the other money.
Exactly, and I'm agreeing with you. My thought is, if it's a disposable income case, and there's money being paid to the unsecureds more than the liquidation amount, then you reduce the amount to the unsecureds to pay the attorney's fees.
I
It's
think we're
as
saying
an
this-
administrative cost.
I think we're saying basically the same thing, because.
You're taking it pre and I'm
when you
taking it
add-
post.
When you add the tax refund into the mix,
Correct?
you're effectively taking it out of the tax refund.
Effectively taking that, yeah, I would agree with you there. But if the debtor needs the $500 for dental work, you're not taking it out of the tax refund.
Let's assume it's a modification for another purpose, to surrender a property. Or
Yeah,
Okay, yeah. then
For whatever, you know,
it has-
leave it-
it
leave it-
has to reduce the unsecured distribution.
correct. You want the unsecured distribution
If you're gonna
reduced
do
rather
that-
than raised.
If you're gonna do that, you have to move to modify the plan or the order confirming plan as to the distributional amount,
Again,
and reduce it by 250,
right.
or
And,
whatever.
and my thought is, why don't we just have a hard and fast rule that says if it's paying more than liquidation, that money will come from the unsecureds. You see what I mean?
Okay, I'm agreed.
Rather than have to go back and
I'm
undo all
agreed.
this.
Now all you have to do is get the person up on the bench to agree.
But I would just say, if it's what do you call it, a liquidation case, then you got no choice. But if it's a non-liquidation case, then we're good. We could
Why?
be.
In a liquidation case, the rules should be the same.
It could be. It could
Because
be.
the attorney's fees are admin expenses.
I agree.
That come out of the Chapter 7 liquidation number.
Richard, we're on the same page on this. I'm just trying to compromise it for everybody to make it easy. What I want is a best practice. How do we handle these issues when they come up? Why should they be novel issues rather than we should be able to discuss these and get an opinion on it as to not you know what I mean, but as how are we going to handle this with the trustee's office? So Mr. Rivera reached out to the trustee's office. Unfortunately, they couldn't be here, but they said they would set something up for us to come and talk about these issues one day, which I said, great. But we need to give them an agenda so they can prepare when they come down. And again, these are just issues we came up with.
Don't expect to get an answer.
I won't. But Richard, I just want to open it up. And what about the cost of service? I don't know how much it's costing you guys for service, but it's costing me a fortune for service every month on all my clients. I'm sure it's costing Richard a fortune.
We should go back to the BNC.
Not gonna happen.
You know,
It's not.
But there should be an easy way to get it,
But there should be an easy way to get it rather than have to file an application for your costs.
and then serve the
I mean, you
application.
use certificate of service, right? So, yeah. And again, that's an easy way to do it, but when you're looking at Chapter 13, and how many applications do you file a month in your sevens, on average?
You mean,
We included in the final.
You include in your
It's
final.
Included in the
So the
final
money's all in
application.
there already. Yeah, for us, if I have to file an amended plan on 30 cases in a month,
when you file the motion to file the amended plan.
you have to ask for cost.
Fees and costs at that point.
yeah, that's
And just
essentially
double.
what we do at the end.
But again, in a disposable income case, where's that money coming from? And again, it's not uncommon to have a debtor with very little money in 13, but 50 creditors. They have to be served the amended plan. They have to be served the motion to amend the plan. They have to be served the order. Where's that money coming from to pay this? And again, if it could come from the unsecureds, I think it should come from the unsecureds.
Because you have to serve the order?
Yes,
Because we don't serve our orders.
we do.
Only if interested, only those that object.
If the way we read the rule, you have to serve everybody.
We have
The
to serve
orders?
interested
I
parties.
know.
So for example, if you have a confirmed Chapter 13 case, you
Yeah.
file those people that have filed claims in the case.
Only the people who file claims.
Right.
Okay?
Yeah, once the bar date's run.
Correct. What if you have a lot of
You have a lot of claims in 13 and you don't
Right.
have necessarily 7.
And that's one of the things you're facing. So I know approximately what it costs me. I can get it really close to what it costs me in postage every month on these things. That's unreimbursed. And now the theory in our office is very simple. Every 3 months, unless we can get an opinion on this, every 3 months, I'm going to flood the court with applications for admin expenses. I don't think that's going to go over too well, but it's going to have to be dealt with.
We're gonna follow right on your sugar.
And again, yeah, I mean, it comes down to it, somebody's gonna have to take the hit. But if I can get my software where I want it to produce these things for me easily and quickly, and all I just gotta do is boop, 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 I'm gonna do it. Because the cost is so great, Richard, it's insane. And I'm sure you have to deal with the same thing. It's a big cost. And again, it just is what it is, but this is something that we gotta talk about. And Can we, Dave, what was this last one? Oh, can we get a motion to, oh, can we get a no look on an easier method to approve it?
It was a follow-up point to that.
Okay. Yeah, and again, like, let's say, for example, an amended plan cost you $175 to serve. If the no look is $200, can we just file the application and have it, you know, with an order saying approved? I don't know. This is what we get on the steering committee. The goal today, folks, is to get to thinking about these issues in Chapter 13s. Hope I didn't bore everybody to death, but these are really concerning to us going forward because it takes time, it takes effort, and that's a cost to your business. If something's costed my business, I want to know about it. I want to see if I can either reduce it or change it to make it efficient using technology. That's what I want to do because I don't think we waste a lot of time on these things. And again, a lot of costs. So if I can recoup them in some way that doesn't hurt the debtor, then I'm glad to do it. But if it's going to hurt my client, that's a different story. So anybody have any questions? If you do, if you have other issues you want us to address with the steering committee, please email them to me. They're very serious to us. We'd like them to be serious to everybody. Any changes we make for the debtors will be better for all of us. Thanks, and have a good day.
All right, thank you, Carmen. Following up, I am working with the Chapter 13 trustee. What they have offered to do is to put on sort of like a half day or a full day CLE on Chapter 13 issues, sort of like a nuts and bolts. Sort of like a nuts and bolts on Chapter 13 issues, and then also specifically address some of these issues relating to the new model plan and the new first day order. And so what we are looking to do is try and find a date that's convenient to the Chapter 13 trustee. And I think he would, I assume that the 13 trustee's office, if we were doing a full morning or a full day CLE type, would invite members of the bar like Mr. Dellutri to participate in sort of, or Mr. Feynman, the brains behind the operation, to give, sort of present that, more the debtor's bar's perspective. But we're looking at, I circulated some dates in July. Maybe it looks like it'll be a little bit farther in the year, maybe third quarter. But we are working to put that together, and we'll apply for CLE credit. I imagine that we could probably do that, do it here on a bare bones, or if it's going to be a whole day thing, we can find a location to do it and probably, have a lunch served or something like that. So certainly if you guys have any ideas for that presentation, if you want to be involved as a presenter, let me know. I'm working with Mr. Cecil to put the date together. If anyone has any strong feelings about when it should happen and where it should take place and what should be the format, please let me know. The only other item is if anybody, I've sort of fallen behind on my personal to-do list on this item, but the Pro Se Legal Assistance Clinic in our division here. I have, as many of you may be aware, there has been a district-wide Pro Se Legal Assistance Clinic that has been formed. When I say district-wide, basically there's an umbrella organization that's been incorporated. There's a 501c3 application pending, and it has received funding from the Bench Bar Fund. Funding that is intended to be recurring for the purposes of maintaining what we call a Pro Se Legal Assistance Clinic in each of the divisions. I think that reasonable minds can differ on what that means, but I think what it would mean for our division is likely a clinic that is open and staffed during the consumer calendars for the purposes of assisting pro se litigants, pro se debtors, and the judges and the trustees in getting these issues resolved. I know many, if not all of you, have volunteered in the past to step outside in the hallway with a pro se debtor and point them in the direction. This would alleviate that need. So there is funding available. They are hiring an administrator that would deal with all the intake and the screening, and then there would be funding for sort of the infrastructure that we would need to do that. And Judge Delano has expressed a willingness to allow us to use, one of the meeting rooms, one of the witness prep rooms. I imagine that we'd, acquire, a laptop and a printer or something like that, so that whoever's the sort of on-call person during that particular docket has everything they need, fee-exempt access to PACER, access to the forms, and so you can point the debtor in the right direction. This is not a, it's not a true legal clinic. You wouldn't be taking on the representation for the life of the case. This is just helping the debtor one-time sort of deal with the particular issue that they have that they need assistance with, and then certainly you could point them in the right direction. This may become, for those of you that choose to volunteer, may become a client, a paying client down the road. Oftentimes, these pro se parties are not indigent. Maybe you'd refer them to, if the event that they are indigent, you'd refer them to a legal assistance organization that could help them more on a full-time basis. But that's the sort of infrastructure and the idea that's in place in district-wide. There's some variation of that is in place and operating in Tampa, in Orlando, and in Jacksonville, and to some extent, I guess, we're unfortunately the straggler. If anybody would like to work on that project with me, I would be, or you have any strong opinions on how we get it off the ground or what our particular clinic should be. I don't think that the bench bar fund and the pro se legal assistance clinic will support a full-fledged clinic like what Stephanie and Greg were trying to get off the ground with Ave Maria, but this is probably a good first start, and it's certainly better than the system we have in place. So I think that it's something we could get off the ground relatively quickly. I just need folks to help us with organizational aspects. As I think all of you know, I don't represent debtors, so I don't necessarily know all of the issues. So maybe someone can help me with those, bring that perspective. And then if you're interested in volunteering, I would imagine, this would be, your commitment would not be sizable. I got to think that there's a good bit of us that are willing to volunteer. And so, you maybe get called on for a couple hours or an hour, a quarter, if at that. So if you have any questions or want to help out with that, give me a call, send me an email, we'll get you involved. All right. Does anybody else have any announcements? Diane? Bob? Mr. Cecil? Caught him with his mouth full. All right.
Just curious on that clinic, are you envisioning sort of replacing the walk out of the courtroom assistants and just putting someone back there, or are you looking to set them up maybe a couple days in advance in case they have to gather stuff based upon what we tell them, et cetera?
So I think that, so I met with Judge Delano a few months ago and talked about what she, from the court's perspective, what she envisioned and what she saw the need to be locally. And I think what she thought, or what she envisions, is to replace the, step outside with Mr. Feynman or step outside with Mr. Champeau. And so you'd have something more semi-permanent. I imagine that we would put up, some posters in the 341 room, maybe have some sort of placard either in the, the ante room to the courtroom, that, some sort of poster that says that this is available. The other clinics have a phone number that's attended by this administrator, and then I think you could have like an intake form on the website. So certainly.
But it wouldn't be at the time of the hearing, it would be a scheduled time, other time?
It would be a scheduled time. The way I envision it, and I think this is the way it's done in Orlando, they have open office hours. They have walk-in hours. All the other clinics have walk-in hours. But they also have more than one judge who holds court more than once a month. And so there's a need, and they have a clerk's office. So there's people coming and going. My understanding is that there are not a lot of people coming and going on a daily basis, aside, I guess, perhaps from the 341s. In a perfect world, I guess you could have somebody available at every 341 calendar, but I don't know that we'd have the means, the manpower to staff that. So I think you would have someone available either before or during the hearings to assist, and then by appointment. All of the other clinics in the district, it's like a one 1 hour consultation. This is not, you don't form an attorney-client relationship, and there are waivers and forms that the debtor or the creditor, I guess you could help pro se creditors also, they sign, that they understand that there's no attorney-client relationship being formed. They waive, they waive any claims or release any claims against both the clinic, the district-wide, the particular clinic, the district-wide clinic, and the lawyer who's providing the services. But to answer your question, I think you'd have walk-in during the calendar hours, and you'd have by appointment that would be set up by the administrator. They have it in place in the other districts. The organization, I think the initial grant was something like $10,000 from the bench bar fund. And I think that when they applied for it, they sort of intended it to be a one-time, but the indication from Judge Conway, from Judge Howard, who's the chair of the bench bar fund, District Judge Howard in Jacksonville, was that this would be a recurring or could be a recurring allocation. They do, I think Orlando has its own full-time administrator. Tampa had its own full-time administrator. They have either let that person go or in the process of letting that person go and transitioning to shared with Orlando. And I think we're looking for someone who would handle all four. Mr. Cecil.
Why don't you guys do that district-wide with people who are available for those consultations? Do it district-wide.
That's what we're doing. And so the infrastructure is set up for a district-wide clinic. What happened, sort of the genesis of it is that Tampa started doing their program, Orlando had their program, Jacksonville had their program, and then with, this is sort of a spin-off of Bless, and maybe Paul can give some better background. But someone had, maybe it was Judge Gentleman's idea with the whole, her theme being think district-wide. It was just incorporated, I want to say we finalized it maybe late, third or fourth quarter of last year. The 501c3 stuff is still being done, but they're operating in the other divisions on it, and we're transitioning towards a district-wide basis. There's a board, and we meet by telephone monthly, and talk about ways to further transition. And Orlando has a great website. If you're curious on this, I forget what the website is. I think if you were to Google like Middle District of Florida Pro Se Legal Assistance Clinic, you'd get theirs. But they have forms, releases, ton of information about how they run their clinic. Justin Luna and Jill Kelso are real passionate about this. We've done a lot of the legwork, and so this is an opportunity for us to just pick it up and run with it. I personally think, it's not perfect, but it's a great idea. And we could have it implemented July 1st, right around the corner. Paul, did you have anything to add on the genesis?
No, you're right. It was born out of Bless.
It was born out of Bless, and then
District-wide program.
and there's Bless funding also. Bless has also made, that's not the only funding source. Bless is funding the other clinics, and so your bar dues to the district court are paying for this in the other divisions. To the extent that you're involved or participate in any cases that source Bless funding, it's paying for this in the other districts, and we just need to put it together and staff it, and we could have it here locally. All right, with that, we'll stand adjourned. Thank you very much, everyone, and thank you, Carmen, for your presentation.